All right, good morning. I'm nervous. You didn't tell me about the podium. So, I'm going to try not to. So you all know a little bit about me. I want to know how many notaries and typics are in here today. Okay. All right. Woo, there's two of us. There's two of us. Three of us. Okay. Everybody else just wants to hear the stories. All right, so really good information. Miss Sherry, woo, you brought back some memories and some stories and things that I've encountered. I want to go back to that one story that you talked about, junior, senior, before I go into this. That happens to me all the time. You get to closing, they present an ID. Your documents say one thing, your ID says something else, you know, however they take application. But in particular, there was a young man who said he was a junior. His ID said no. I said, well, sir, why are you a junior? You know, your father? Because I want to be. Just because I want to be. Well, that's kind of not how it works. And the reason why I do not use my notary outside of work. So, all right, let's talk about deeds. Although I have many stories. Go ahead. All right, well, she's already told you about me. All right, everyone knows what a deed is, right? So in real estate, the deed is the most important document, transferring the property from the current owner to the new owner. Now, when I first started in real estate, I hated how people would call it title. You get a title for your car, you get a deed to your house, right? It sounds so much more important. Okay, so I'm hoping that when you talk about deeds or homes, that you're going to call it what? A deed, not the title. I've also learned that every deed tells a story. So now I'm nervous when I go back to work on Monday looking at title because of some of the stories that you told. I'm really going to have to pay attention, huh? All right. All right. Now, in the perspective of being a notary that I might have hired to sign deeds for me, because you do not need to have a license, a title license, to notarize a deed. We all agree, right? But I need to rely on you to make sure that the documents you're signing and the people that are signing, that it's being done correctly. Now, how many of you have notarized a deed? All right. Do you actually read it when you notarize it? Can we get in that practice? You know why? Sometimes if names are spelled incorrectly, like junior, senior, and you've grabbed the ID, there becomes a big, huge problem. The date. Now, again, you heard I work in DC. I know we're in Maryland today. Date is really important in DC. They are very strict about their dates.
Which date?
Both the notary date and the date of the document, right? So in DC, the date of the document, even if the seller pre-signs, must match the notary date. Where in Virginia or Maryland, you can sign your deed 2 days before closing. Notary date is one thing, deed date is another. Tenancy. So do you all know what I'm talking about when I say tenancy? Everybody does?
Do you happen to be talking about joint tenant, tenancy in common, things?
Yes. Thank you. One of my favorite things. Do not make sure that you read the document, okay? Now, of course, you would assume that when it comes back to the title company that we're going to verify it, but read the document. The tenancy is important. Stating the interest. You know what I mean? The transfer amount. Make sure that you acknowledge it and notarize it properly. Spelling is important. In Maryland, we need an attorney certification. DC, we do not. That's another scary thing. Virginia has to be prepared by an attorney. All right. It's hard to see this way. All right. So going back to some of the things that Ms. Sherry said, identifying who is authorized to sign the deed is really, really important. So outside of an individual, we have a lot of transfers that come from an estate. Have you ever seen an estate deed? Yes. Who is authorized to sign on an estate deed? Personal rep. But I've actually seen deeds where people sign the dead person's name. How does that work?
Can't do that.
Can't do that. Can't do that. So I, as a notary, again, I don't use my notary outside of work, but I, as a notary, if I was given an assignment, I would still want to verify as much information as possible And there's no reason why you as the notary, getting ready to execute a deed, going from an estate to a party, that you should ask for verification that you are authorized to sign this deed. Would you agree? Yes. Do you know what that authorization is called? Letters of administration. It's a one-page document. It's given to the party by the court. It's stamped, and it has their name. Do not be afraid to ask for that document. LLCs, that's a problem. We have a lot of people that are purchasing properties. I know here in Baltimore, I live down in Charles County, not so much, but in Baltimore, and they're buying them through their LLCs. Again, that person has to be authorized to sign the document. I've reviewed title where I see that the entity signed a deed. How does that work?
They can't sign it.
They cannot sign. So if I own ABC Company, they cannot sign ABC Company. But there have been documents that have been signed that way. And I'm going to tell you, the clerk's not going to look at it. She doesn't care, or he doesn't care. They are there solely to record and make sure we've given them enough money to record. So as a notary, if you're given a deed and it's currently in the name of an LLC, you need to ask for authorization. Do you know what that document might be? What's that? Articles is one. So they need their articles, their operating agreement. But what I would say to you is ask for a resolution. The resolution will show you the names of all the members, or if it's a sole member LLC, it'll state that. Verify that against the signature and the ID. It's really important. So I'm going to pause here for a minute because, again, Sherry, you had me thinking about this terrible 2020 transaction we had. So our office was asked to do a transfer for a Redskin. I don't watch football, so I don't know which one it was, but I know it was a $3 million transfer in Virginia. Big deal for us, though, you know, big deal for us. Young man paid cash. Now, not only am I a notary settlement officer, but we sell title insurance, right? Thank God he bought title insurance. He lived in the property maybe a year. 2021 comes around, and we're notified of a claim. This claim was for a forged deed, but for a forged deed, two owners back. So not even our transfer, but for somebody who forged the deed, two owners back. The person who is filing the claim is an heir. Someone forged an estate deed. Now, as a title company, do we review the records? We absolutely do. But as it was stated before, it's not necessarily our responsibility to verify everybody's signature. If this was previously insured or previously closed with another title company, I am making the huge assumption that that title company verified everything. However, when we pulled our file and we printed everything out and we looked at the signatures, it was clearly forged. Clearly forged. So currently, our underwriter and two other underwriters are in litigation to see whose fault it was. And it's a huge, huge claim.
And the Redskin owner does not own the home.
He sold it.
Right.
He did sell it. He did sell it. He did sell it. But she came in afterwards to say, hey, you know what? This was my grandfather. It was the same old story. It was my grandfather's property. It's big land. We didn't get paid. He didn't sign that deed. Where's the money? Where's the money? Questions so far? I don't want to bore you. All right, so transfer by guardian. I heard someone talking about this earlier too, about guardianship. Again, now that would not necessarily be a deed that a title company would prepare. I would think more so someone would call you and say, hey, I need a notary. Be prepared to ask for the documentation. If a transfer is being done because of a guardianship or someone has been appointed as a trustee through the courts, there has to be a document with it. Not only should you ask for that document, but we, or whomever, should record with that document. Transfer by power of attorney. That's one of my least favorites. So how many of you have notarized the power of attorney? Did you ask any questions? Did you ask for any questions? those are the worst. I hate doing the power of attorneys. Generally speaking, I do not use my notary stamp outside of closing my loan because in the past, when I trusted a colleague and they asked me to notarize a power of attorney, he brought his mom in and asked me, can you prepare this document? We did. Will you sign this power of attorney for my mom? Not a problem. He brings her into the office, and the first thing that I notice is they have to guide her to the chair. I'm like, okay, here we go. She sits down, and she sits in the chair. We're just chatting a little bit because, again, I don't use my notary outside of work. I'm not real sure what I should ask her, but I know I have to ask her something. So I ask her for her ID. So I get her ID, verify her ID, then I hand her the pen, this pen right here. I show her where to sign. She takes it upside down. She doesn't know what to do with it. And I say, okay. So I say to her, I said, ma'am, do you know what today's date is? It's really pretty outside. She was like, whatever day it was. Let's say it was a Friday. She's like, yeah, it's Wednesday. Okay. At this time, Obama was president. I knew she would know this answer. I just knew she would know this answer. So I said, okay, do you know who the president is? And she sat there and she played with her pen. She played with her pen. And then she said, baby, I do not. So I walked out of the room, pulled my colleague out and said, she has dementia? He says, yes. I said, how can you set me up like that? She cannot sign a document when she has dementia. And I promise you, from that day forward, I have not and will not use my notary outside of work. Do you guys have any questions? If not, I want to talk more about power of attorneys. So I have a file right now, whereas a good real estate partner contacted me that she has a property that is going to be listed. It was a husband and wife that owned it. The wife has died. She says, I don't know if the husband is on title. Can you find out? Not a problem. So I find out the husband is on title. The problem being that the husband is in Palestine. I said, okay, he's in Palestine. Well, he can go to the, he can go and have it done at the embassy or what have you. No, we have a power of attorney for the son. I said, okay, a power of attorney for who? For the mom, but she's dead. It doesn't work that way. Well, apparently he made it work that way. He signed her listing agreement. Yeah, he signed everything with her not being here anymore. You know what? I thought for the longest time that was common sense. But over the course of my career, I find that is not common sense. Someone believes if they're given power of attorney, that's forever. But it's not. Yes, ma'am.
They also think it means that when the person dies, that they are automatically the executor or the representative
That too.
of the estate.
That
they
too.
just assume that transfers, but it does not. It's two different things.
It is two different things, and that's why if you are a notary and you have not yet taken your title insurance class, but you want to close loans, please at least take some education, because things like that, big mistakes can happen. When we employ notaries on the seller side, because you're not selling title insurance, you're working under our license. So I'm praying that you would do exactly what I would do in that instance. And there's been a few times where things come back incorrectly, we can fix it. But if you have the knowledge, and just like Sherry said, be extra, ask the questions. The other day I was presented an ID and it looked funny to me. And the person was like, well, I don't understand the issue. I said, well, the issue is not only am I the closer, but right now I'm in the capacity of a notary, and I need to verify your identification. And if you cannot present me with identification, we don't close the loan. It's that simple. Yes, ma'am?
I was going to say, with title insurance, the notary is the only person that actually sees the signers at the end of the day. So we have to be the eyes and ears for the title company, because you're not going to think about asking, did the wife pass away or did the husband pass away? But in our conversation, we're going to find out, oh, the wife's not here, but she's supposed to be signing. That's when you step out and you call title company and say, hey, wife just passed away. Do you know that? And then we're like, no. We're like, okay, closing needs to be redone because it switches everything around.
It's important. We have to work as a team, right? We have to work as a team. I rely on you to be my eyes. I can bring it so far. All right, so McCall wanted me to speak about the different types of deeds, but before I go on, I probably have another story. Well, I actually have a question, maybe a statement. When you were talking, Sherry, about the title company that the young lady signed, notarized because it was a friend, that the courts did nothing. But the court case will show up, right? District or circuit?
It's, that court case is a circuit, it's a state, it's an appellate court.
So
It's already gone to the appellate court, and it's an appellate opinion.
what will happen is, if he tries to sell that property, that will come up during the title search, and it will be a title flaw, and it's not going to be able to be transferred. So there's his punishment. Because we only search for circuit. We don't care about district. All right. So there's different types of deeds. Maybe you want to know about them, maybe you don't, but I'm going to tell you about them anyway. So the first one is called a deed of gift, okay? There are many jurisdictions that they use a deed of gift, but there are many jurisdictions where they are exempt from transfer and recordation, but there are other jurisdictions where they are not. So I'm going to try to stay in Maryland. Maryland does not necessarily see anyone to give a gift of deed. They always want to be paid. Now, Maryland being so big, and each county and city, yes, sir?
Could you repeat what you just said?
Yep. So deed of gift would be, maybe I want to gift my property to my child, okay? Or I want to add my child to my deed. Certain jurisdictions, it's okay, just a recording fee. Other jurisdictions, you're paying transfer and recordation because there is no exemption. Maryland is one of them, but not just Maryland, but then you have your counties and your cities. There might be a little bit of an exemption, but not too much. Sometimes, or most of the time, when you're gifting something, your consideration is what? Zero. It's nothing. However, that does not mean that there may not be tax consequences for the person who's receiving it. And by the way, I am not an attorney and I'm not a CPA. I am a lonely old title agent. All right. This word I cannot stand. Quit claim deed. Quit claim deed. I understand that this word or this term is used a lot, but I worked for some fabulous attorneys over my career, and my one attorney told me that is not even a real thing. A quit claim deed is not even a real thing. So when people say to me, they call me, hey, LeeAnne, I need a quit claim deed, I said, you need a what? Because I don't understand what that means. But what it is just a quick way to transfer your interest to someone else or remove someone's interest from the property. When is it used? Mostly upon death, meaning especially if there's a husband and wife, and while you do not have to remove the deceased party's name, especially if you hold title as tenants by the entireties, because it is assumed that their portion goes to you, some people just don't want to see that party's name on there, okay? Give me a second, I gotta clear my glasses, yes?
It's only used in the courts.
No, we type them.
Quick claim deed is used in the courts.
Mm-mm.
You have to go to the court to get that.
Mm-mm. I'm gonna talk about how you get deeds and why you should be mindful of where you get them too. Sometimes with death, again, somebody's husband or wife passes away, we get calls all the time, can you prepare a quit claim deed? It's not necessary if they held tenants by the entireties, but some people just want it removed. Divorce. This is another tricky one, okay? Sometimes when they have the absolute judgment of divorce, it says, hey, husband gets property or wife gets property. However, never take your name off a deed if you still owe on the mortgage, and I'll just leave it at that. Marriage, somebody gets married, you're all excited. Hey, honey, I want to be on the property too. You put them on the property. We're going to pause for a minute. You asked me a question about where to get deeds. Okay, so I like Maryland so much better than I do DC, and Virginia is much easier. In Virginia, preparing a power of attorney or a deed is considered practice of law, which simply means that no one in our office except for our attorney can prepare that deed or that power of attorney. I love that because then it's all on them. In Maryland, as long as it's under the supervision of an attorney that is barred, or the deed can be prepared by a party to the instrument. That's the part that makes me nervous. So, story time. Baltimore. I had a listing agent send me a contract. The young lady who was signing all the documents stated that her aunt had put her on the deed some time ago, but her aunt had since passed. Not a problem. We run the title comes back. The young lady decided that she was going to use a deed online and give herself interest in the property as a party to the instrument. The problem was, or the problems were, A, no tenancy. B, when she added herself with her aunt, she also included her deceased uncle. 3, the notary looked funny. I showed my attorney. He said, okay, we can move forward, but you need to do A, B, C, D, E, F, G. So you heard me say no tenancy. So I had to break the news to the young lady where I understand that you want to sell the property and you want to get some cash. However, when you created this deed, instead of contacting the attorney, you created it and you didn't create it properly. You forgot to add a tenancy. And she was like, okay. I said, well, in the state of Maryland, if you do not include a tenancy, it defaults to tenants in common. What is tenants in common? Does anyone know? Tenants in common.
Equal shares.
Exactly.
Goes to equal.
It's assumed that you own 50, I own 50, but there is no protection. Your 50 does not come to me, and my 50 does not come to you. So now we have a deceased uncle, a deceased aunt, and a young lady who thought she was getting $300,000. She argued with me for days, talked about the fact that she had the power of attorney, which she thought meant that she could oversee the estate and just take care of what I said. I said, no, ma'am. You now have to go to the court and you have to open the estate. Well, you know, of course, as time goes by, you get a little bit more information. I believe, in this instance, she purposely did what she did. I'm not even sure if her auntie really signed that deed, because then she says, well, what about my cousin? I said, what about him? Well, that's her son, and then he's the heir. That was a problem. The sole heir. So I felt after speaking with her a little bit that I felt like, again, it was purposeful. The deed looked funny. The deed looked so funny. Like the legal didn't even have a right legal. It just had the lot and the block. The signatures looked funny. It was handwritten. It was like fill in the blanks. Yeah. I'm still dealing with that one, just so y'all know. That was fun. All right. Warranty deed. All right, so warranty deed is probably the one that you would see the most in any type of real estate transaction. And forgive me, again, all I do is real estate. I'm a real estate nerd. I'm a title nerd. So everything I say is going to be about real estate. Those are the ones that we most commonly use. So with the title companies, generally speaking, that's the type of deed that we create. A general warranty deed just set, you all can see this, right? Warrants to the purchaser that, yes, I as the seller, I own the property, I have interest in the property, and to my knowledge, there are no defects with the property. It's usually a 2-page document, depending on which attorney I have prepare it. Some go over, some go under, but it's the most commonly used deed. Now, I have some prizes in my bag, so I'm going to ask some questions. When I first spoke, I said one of the most important things that you need on a deed didn't need to match. There we go. I got you something. The dates don't need to match. The date of the notary versus the date of the deed do not need to match in Maryland. You guys have any questions? Are you excited about deeds?
Yes.
I can tell.
I have a quick question.
Yes.
Oh, somebody have a...
Now, I said it's a trick question, only because you mentioned DC earlier as well, so.
Well, we can talk about it.
You didn't say Maryland, but I assumed afterwards, after she answered.
Oh, he wanted his prize. That's what he would.
All right. So I said, okay, then I'll give you another question. Of all 3 jurisdictions that I work in, which jurisdiction can you completely prepare your own deed? You had the answer. You just said it. You said DC. DC is the only jurisdiction where you can literally just, you pull it. They have it on their website. The DC Recorder of Deeds says, here you go, fill in the blanks. That'll bring me to another story, but not yet.
So I had a quick question.
Yep.
In your company, are there a number of warranties that you have to see before you issue a deed? I hope that makes sense. Like what warranties have to be given before you can say, okay, this is a deed that, you know.
It depends on if you get title insurance in an abstract or you're just having a deed prepared. So if somebody calls and they just simply want a deed, that goes to the attorney. The attorney then indicates no title insurance, no opinion of title, transfer because of blah, 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 blah. If we're actually doing a transaction, we have to read the title. And when we are doing title, we go back a minimum of 60 years. And we have to make sure all the transfers are correct. But now Ms. Sherry has me nervous. I'm going to look at every deed in that package. I'm going to compare every signature. I'm going to get the processors to do the same. I'm scared now. All right. Not my favorite. Not very common. Was more common around the market crash. The deed in lieu. Deed in lieu is just simply a deed that the owner of a property who's in distress and possible pre-foreclosure, you give the property back to the bank. Here's the caveat. It doesn't eliminate or clear the title. The lien still seemingly is there. Our underwriters are a little skeptical and a little harsh when it comes to a transaction that has a deed in lieu in the chain because of the fact it doesn't necessarily wipe out the mortgage like a foreclosure. We all know if somebody forecloses, what happens with that mortgage is gone. And all the junior things beneath it are gone. Tax sales, I was talking to somebody about that before. When you buy a tax deed or tax sales in Maryland, if there's a mortgage on the property, if there's liens on the property, it does not go away. They still remain and now become your problem. But the deed in lieu is basically for you to give the property back to the bank, and they actually used to pay people to do that. So it was easier for them to give you $10,000, $20,000 for your property versus going through the heartache of foreclosing. Yes, ma'am.
I just wanted to point out that often, just from a consumer's perspective, be very careful that you preserve any release from that mortgage, because then I had a property where they didn't give me the release, and it wasn't even a deed in lieu. I was selling the property, and the mortgage was taken care of. And when it was time for me to sell it again, for my sale, the deed, the release had never been done for the prior owner, and so it looked like there was a lien closing along with this deed. Why it wasn't caught when I purchased it, I don't know. But now here I am trying to sell it, and I'm blocked.
But you had title insurance, didn't you?
Yes.
You were good.
Yes.
See? No, it happens often. I think recently there was a law put into place that the banks now only have a certain period of time to release the mortgages. Before, it used to be more of a responsibility of the title company. Now, not so much. But it happens all the time. Thinking back to before the market crash, when people were refinancing hand over fist, you couldn't record a new mortgage quick enough to release the old one. And by the time, you release this one, they've had two more. So releases, especially like in Prince George's County and Baltimore, I mean, no disrespect, I'm down in the woods, but those two counties, maybe because they're so big, their records are always really behind or misindexed too. So my slides are really, really short, so I'm going to need y'all to ask questions. I was told I have to stand here for an hour. At least give me 10 minutes of questions, something. Or do you want more stories? I'm stuck with stories. All right. So we had that one transaction where I told you in Virginia where it was blatant that somebody forged a deed they stole. Then we had the other one where the young lady in Baltimore, I feel, just personally, it was blatant that she was trying to take this lady's property. Then I had one in D.C. So because in D.C. you can pull down the deeds yourself, it was pulled down, it was filled in, same kind of scenario. The young lady, but they were not relatives. The young lady said that her godmother said that she wanted her to have the property if anything happened to her. Okay, fine. Well, when we pulled the deed, again, no tenancy. And again, she could not understand what effect that had on what she was trying to do, but she also used the power of attorney to deed the property to herself, which in our industry should be a red flag.
There's no checks and balances there. And if you're talking about, this goes to elder and vulnerable adult fraud, financial exploitation, because often that person is grandma's property and granddaughter or great-granddaughter's like, I am tired, take care of her, and I need money, and I'm not going to let the rest of the family get this. She's going to give it to me now. She would want me to have it.
Yep.
And, you know, they do all of that because they got the power of attorney, and they think they can do that, and it's all to their own gain.
Yep.
All to their own gain. They have the power of attorney, that's their first step. Then they transfer property and assets to themselves. They withdraw money out of the bank for their gain, and they don't understand that that's a crime, because they are, unless it was given to them and consented and transferred, you'd have a lawyer involved or something. But just doing it all privately, and one person is doing all those transactions, they're no longer acting in the role of a power of attorney. Because most power of attorneys require the person to have a fiduciary obligation to do, all their actions should be for the benefit of the individual that they have their power of attorney for, not for their own gain.
100%.
So when you're doing it for yourself, you're not.
No, you're not. You're not thinking about the person. I also think that a lot of times when people are using the power of attorneys to transfer property to themselves, they steer clear of title companies because they know we have attorneys that, you know, that's considered law work, and we would give that to the attorney. They'll find a notary, and if you don't know what kind of schemes or scams are out there, if someone ever presents you with a power of attorney to sign any document, please scrutinize it. Please scrutinize it. I would even go as far as, in closing, even though the power of attorney might have been reviewed by our underwriting attorneys or the lender's attorneys, I still personally ask for a copy of the ID for the principal. And we can go back and forth all day, but I need a copy of the ID for the principal. Then we also make them sign an alive and well that says that the principal, which is the person giving the power of attorney, is still alive and that they're coherent. Because the first time you tell me anything, if you accidentally tell me, hey, LeeAnne, I'm using a power of attorney for this transaction, and I say, well, we can drive to them. Oh, no, they're in a nursing home. Or, oh, no, they have dementia. Well, how old is that power of attorney? 6 months. How long have they had dementia? 2 years. We can't move forward. We won't. The rule of thumb for me, personally, if somebody brings that to me, is if your power of attorney is more than 2 years old, I need a fresh one. If you don't have a fresh one, then I need a letter from a doctor stating that at the time that this was executed, that you were of sound mind. If you can't provide that to me, I'm not putting my signature on there. I have to keep my job.
Yes.
So I have a question.
Yes.
So what happened with the adopted daughter? She didn't have.
Not under my rule, but I did advise her to reach out, that she should probably reach out and gain assistance or get help at this point.
She was
because
legally adopted. Would she be the heir?
There's other children, and DC's complicated.
Yeah. So
DC, everybody's an heir.
It's like all of a sudden of interest, and they are literally trying to, or at least last I heard, they had found a lawyer who has some type of interest or is in support of these 3 family members, moving her out of the house where she has actual care. And I warned them that was their first step.
Yeah.
Yeah. So I come from a healthcare background too, and so I did let them know that once she's out of the house, it's going to be really, really hard. The fight is going to get harder once those family members move her physically out of her own home and into their care. that they're gonna create a story similar to what he shared about the ghost guardianship. I can feel it, I can smell it from the onset that's what was in the works. And so I told him, no, I would not be providing the services.
Everything makes me nervous, and I think I drive my attorney insane, but I question everything just because I don't ever want my signature on something that I could have prevented. Yes, ma'am.
Unfortunately, my friend just lost her mother, and there are properties. And the mother, the one property the daughter lives in, she says, okay, that's going to be your property, it's yours. When I'm gone, that's it. There's a second property, however, the second property, the main property, has a reverse mortgage on it.
They got 6 months to get rid of it or they're foreclosing.
But the thing is, the daughter, it's a daughter and a son. The daughter doesn't want the property that the mother has given her. The son wants the daughter to take the property the mother has given her so they can sell that property to resume the main home. But what I'm trying to understand, what I'm trying to understand is because I don't know that there's a document that says this is your house.
It doesn't matter. I'm not an attorney, but I'm going to say this anyway. Open an estate, list the heirs, get rid of the property with the reverse mortgage, or they will foreclose on it. Because I had a friend who I did a transaction for. Her mother had been deceased for 2 years. They kept the insurance on there, which you're not allowed to. An insurance company is not going to, you can't, once the person dies, it becomes an entity. Insurance companies don't see friendly to keeping hazard insurance on a property when somebody's deceased. So they have to open an estate to do anything. And guess what? The will, I mean, some people file their wills, some people do not. And ultimately, guess what? The court doesn't necessarily decide what happens with the will unless somebody is protesting the will. All you do is open the estate, become the executor, the personal rep, whatever, and then that personal rep is responsible to abide by the terms or the wishes of the will. But they better hurry up and open an estate. Don't wait a long time. Good. Any other questions? Yep. All right. I am a title nerd. Thank you all, because I was really nervous. I told Nicole I was getting ready to go out and ride back home. I didn't want to stand at a podium. So.